Good morning, everyone. I thought I would put up hopefully a relatively brief review of the concepts of nationalism that developed early on in our constitutional history. Constitutional has been basically amended from the Articles of Confederation. It's really a revolution within a revolution. We have our new constitutional framework after 1791, when the Bill of Rights are ultimately adopted. And what the document really means is, well, it means what the words say it means, but also there's so many nuanced phrases and clauses within it. And we know initially there's lack of clarity in terms of the power of the judiciary. The judiciary is created to obviously adjudicate legal disputes. But what does that actually mean in the big picture really comes to bear after 1803. And we know that's with the Marbury versus Madison case. I put up a video of some other people that have posted, academics and people that are more entertaining than I ever can be, talking about the power and the purpose and the importance of Marbury versus Madison. And most legal scholars, most historians think Marbury versus Madison is the most important case ever out of the Supreme Court. Why? Because it establishes judicial review. And why is that important? We know it really creates the checks and balances really between the executive, the legislature, and now the judiciary. And some people say it's three co-equal branches of government. I would suggest it's not. I don't know if it's in this class or another class. One student wants to do the power of the executive and how it's the most powerful branch of the government. Got to be cautious there. I think that might be arguably the case maybe today or at points in history. But we know when the framework was first developed, the legislature was designed to be the most prominent aspect of government, the executive playing a significant role, but I don't think nearly as equal as the legislature. But the judiciary was sort of left out there in terms of having its own niche of power, but not necessarily being able to put a check on the executive or a check on the legislature. And we know that comes with Marbury versus Madison. There's other cases. I don't want to kill you guys by reading case. But initially, it is Marbury versus Madison establishes the power of judicial review. And what does that mean? That the court can review legislative mandate, law, and declare it unconstitutional and null and void. That's a huge check on the legislature and really a huge check on the executive, because later sometimes the executive will try to do certain things, and in other cases we'll find the Supreme Court says not only can the court, through the power of judicial review, determine something unconstitutional by the legislature, but it can do the same by an executive actor, and then, which is very controversial, it can actually strike down a state law that's contradictory to what the Constitution mandates. And that's McCulloch v. Maryland, which I'm going to talk about now. So initially, the big case, we're creating the judiciary as a third tier of power that has checks and balances between the executive and the legislature. And now nationalism comes to play. And this is, I'm trying to follow the syllabus to some degree. I know many of you are bored by this, but it's an important concept. How much power will the states have? How much power does the federal government actually have? And I think a lot of the framers said we're going to list the limited powers the federal government has and the rest are reserved to the states. But what does that actually mean? The courts are going to tell us what it means through the power of judicial review. In the first big case is McCulloch versus Maryland. And what is it about? It's this controversial conception of the federal government creating a national bank under a charter from the Congress, and if the president signs up, becomes a law. It creates a 20-year charter. And it was very controversial. Thomas Jefferson thought it was extremely unconstitutional. There's nothing in the Constitution that says that the federal government can create a bank or a financial institution like that. So therefore, it's unconstitutional, according to Jefferson. Hamilton loves it. Hamilton thinks it's the greatest idea. He's the Secretary of Treasury. He said, we need this kind of thing in order to manage the economic welfare of the nation and spur growth and have control over economic policy. We need a national bank. Washington's the president. The legislature passes the legislation, and Washington's torn. He's not sure whether it is constitutional or not. But who wins the day? Hamilton convinces Washington that we should have a national bank. So they pass the 20-year charter. They open up branches of the federal bank in different states, one of them being Maryland. That's why it's Maryland v. McCulloch. And the state of Maryland's upset because it's competing with state banks and with private banking interests in that state. And they say, hey, we don't like this federal bank. So what do? They ban it basically through taxation. They tax the living heck out of the federal bank. And then basically there's a dispute, there's a legal dispute. And two questions ultimately go through the court system and start off with the trial court, but they end up at the Supreme Court of the United States. And two questions are asked in McCulloch v. Maryland. The first one is, does the federal government have the power to create a federal bank? State of Maryland says no way. They're going way beyond the grant of their authority in Article 1, Section 8. The federal government says, no, we do have that power because we don't only have those listed powers, but we have this thing called the necessary and proper clause, which is an elastic kind of an allowance to do things that are ancillary and related to those listed rights and powers. And so therefore a federal bank is needed for things like taxation, collecting of funds, coinage of money. All those things are related to banking, and therefore banking is ancillary to it. It's within the power. That's the first question the court has to answer. The second one is, okay, can the states tax a federal entity like the federal bank that was going to be located in Maryland? So the first question gets answered in the affirmative for the federal government, meaning the federal government's deemed to have very expansive powers because of the necessary and proper clause. In that argument that Hamilton has, that you got to read those listed rights as being able to really be executed without being fettered by technicalities. If there's something the federal government's allowed to do, like coinage of money, taxation, regulating currency, collecting of taxes, dispersing of funds, all of those things are executed through banking. So a bank would be ancillary to that. And John Marshall, the Federalist, he's one of the last. The Federalist Party dies pretty much after the election of Thomas Jefferson, or the successful 2 terms of Thomas Jefferson. The Federalists really fade from existence, except who? John Marshall, who stays on the Supreme Court. He has a very strong opinion about a strong central government, and he has the other members of the court, I don't want to say in his pocket because that sounds like it's illicit or based upon bribery, but it's based upon the fact that he's very persuasive, and he really is able to carry the court in his direction, and the court concludes that the federal government does in fact have the power to create a federal bank. And then later, in another case, which we'll get to in a second, he expands the federal conception of centralized power in the federal government, weakening state rights at the expense of the growth of federal power. The first case, McCulloch v. Maryland. The next question, can the states then just tax it? And my favorite quote, I was saying it the other night, I get these little weird mantras and I'm walking around, and I'm saying it in this weird little, I don't know, sinister accent. The power to tax is the power to kill. And I kept walking around saying that. My son says, what are you talking about? I guess it's a quote from the case. And basically, if the state can interfere or impede the federal goal that the federal government has allowed to do it, it has to be null and void. Because of what? The supremacy clause in the United States Constitution. Anything the state does to put a roadblock or a hindrance, and taxes are a roadblock. Taxes is the power to kill. The power to tax is the power to kill. So it shot down the state of Maryland, both in the question of whether or not the federal government could create a bank, but secondly, whether the states could tax the federal entity, and it cannot because it would impede its purposes. This is what? Federal supremacy over state diminution, states starting to shrink a little bit. The next big case is Ogden v. Gibbons, or Gibbons v. Ogden, and this is significant in that there was basically some steamship travel in upper state New York, and this guy basically had a monopoly on steamship authority through the state of New York. And he had a monopoly, basically a legal monopoly was his argument. Along comes the federal government and says, we're going to give this person a license under the federal law to transport people based upon interstate commerce. Court case comes up, and the question becomes, who gets to regulate interstate commerce? Can states do it along with the federal government, or only the federal government? And the question basically becomes answered. The federal government is supreme, and the federal government does have the power to regulate anything that really impacts interstate commerce. Even if you argue all the transportation is done within a state, intrastate, the federal government might still have the power to regulate it if it impacts interstate commerce. So what does that case really result in? Again, the strengthening of the federal authority in the weakening of state authority. And those two, there are many others, but I just want to, this is an introductory to the history of the Constitution. We want to focus on the big nuggets. Those two big cases really change things. Thomas Jefferson is seething. He hates the concept of the court having all this power. He thinks states should have, he's a states' rights guy. He thinks states should be more preeminent. and he doesn't think the federal government has the power in which the court says it does. An interesting thing happens, and it's not in the material we're reading. There's something that happened when Thomas Jefferson, and I'm going to test you on it, and it's going to come up in some little bit later material related to the great nullification crisis that happens during Andrew Jackson's period of time as president. I would combine the two, but I want to keep these videos relatively short. What happens at the time when John Adams is president, there's this real concern. There's a split in the country between supporting sort of the British view of aristocratic leadership, of the educated and the wealthy really having a lot of control, and then the Republican Democrats of Thomas Jefferson having more of an allegiance with the French Revolution and the Republicans of France, which was considered really radical, scared the heck out of a lot of people in the United States. And so there's this dichotomy within the United States, and it's the Federalist and the Republican Democrats. I hate that term, sounds like they're an oxymoron, but it's the Jeffersonian Party, much more state rights, much more small government, but much more allied with the philosophy of the French Revolution. And then you have the Federalists, and the Federalists are like guys like Hamilton and John Adams, although they're not very friendly, but they are in the same boat about feeling a more aristocratic role in governance. It shouldn't be everyday people participating in civic life. It should be the best and brightest, the educated and the wealthy really should participate. That created such a tension, and there was such a fear over the French Revolution that they created a law called the Alien and Sedition Act. I got to put it on the test. It's so important to know based upon constitutional history. And I think a lot of people would argue that this law was unconstitutional. Not so much the Alien Act. The Alien Act was the ability of the federal government to deport any non-citizen who seemed to be going to be doing sedition, basically undermining the federal government's interests and the people of the United States' interests. They should be able to deport them. I think most people, even back then, said, it's not a terrible law. I don't think anybody or very few people were actually deported as a result of that law. But guess what a lot of people did when the law was getting passed? They left. Many of them were French people that were in the United States. They knew that the law was targeted against them. It angered people like Thomas Jefferson, who felt an allegiance to the French. But a lot of people left the country because of the Sedition Act being passed. I mean, the Alien and Sedition Act, the alien portion of it. That part's not as controversial. What is controversial is the Sedition Act. This actually mandated that you could be prosecuted for criticizing and undermining the legitimacy of the government through comment. Doesn't that violate our free speech? Thomas Jefferson and James Madison were so mad over this concept that they thought it was inherently unconstitutional. Well, the court never got to hear whether or not the Alien and Sedition Act was valid. It was only in existence for a short period of time. Once Thomas Jefferson got in office, it was repealed. I think there was a sunset provision in the law anyways. It was like for a 4-year period, then it automatically dissolved unless renewed, and it did not get renewed. But it was a very, very controversial law. In fact, it was so controversial, and it angered so many people. There were people in the press, writers of newspaper articles, publishers, things like that. There were some, I believe, Congress members that actually served jail time for speaking out in opposition of the government's actions. Today, that would be unheard of under our free speech conceptions. But then it was legal, or at least on its face, it was legal, and people were being punished for criticizing the government. It was really shocking. So what did Thomas Jefferson and James Madison argue? They wrote something called the Kentucky and Virginia Resolves. Basically, these two men were representing Kentucky and Virginia, and they were not in the presidency yet. They were about to be president and vice president, or president and secretary of state, I should say. They wrote these proclamations. They had no legal bearing, but it's really interesting that a lot of people backed it up, saying that states had the ability to nullify a federal law if the state felt it was unconstitutional and against their view of the Constitution. Can you imagine that? Isn't that exactly what the argument of the Civil War was? So when we get to the Civil War, we talk about the complexity of all the different issues, including obviously the major vehicle being slavery, the tension over that giving rise to the Civil War, but it was also these tensions between federal power and state power. And what did Thomas Jefferson and Madison argue? States had the power to basically nullify and rule ineffective a federal law if that state determined it was a violation of their agreement under the Constitution. They agreed to join the Union. They could agree to back out on selective things if they wanted. It was unheard of, but it gives credence to later in the next section about Jacksonian democracy. Jackson has a similar problem with South Carolina. And we know later South Carolina is sort of the launching pad of the Civil War. So these things have been brewing for quite some time. It's not just over slavery, it's over state rights versus federal concentration of power. But after these two cases, what do I want you to get out of this section? And we're not, I think, week 5 in the syllabus. We're a little bit behind, obviously, but it's an important concept. We have nationalism, we have judicial review, and then we have states' rights. And the states' rights are losing, but they're pushing back with things like the Kentucky and Virginia resolves and the other arguments that they have state sovereignty vis-a-vis the federal government. They have a losing cause. John Marshall likes to give states very little power and federal government all the power. And John Marshall's going to be in a court right into the 1830s. But that's just a basic synopsis I want to get from this section. I already put up some pretty good videos. I don't know if you guys missed my little videos, but I want to make sure that you knew I'm there. And I'm probably going to put a video up, if not today, probably tomorrow, going into Jacksonian democracy and the pushback for state rights with John C. Calhoun, which almost causes a civil war earlier in a time. And it wasn't directly over slavery then, it was over a tariff. And then we'll talk about some of the cases. We got to go into the sad part of our history about slavery and the court decisions related to slavery. And there's some other very important ones about contract rights and about state the protection of vested rights is a very important concept. I don't think it interests most students, and it's a big course. There's a lot of material to cover, and I don't want to get too big into the fact that the court repeatedly protects vested rights. The government just can't take away your property or a right that's been vested without due process of law, or can't take it away at all unless they compensate you. And that's a very, very significant principle that still undergirdles our conception of property in the United States today. Government can't take away your stuff without having a hearing and make sure it's fundamentally fair. And if it's not a crime, they can take away your property if they only can justify it, and they have to pay you fair market value. But I'll leave you with that stuff, guys. Hope everyone's doing well.